Hey, my name is Pete Mark, and I'm a certified probate specialist or expert here in Denver, Colorado. And joining me today is David Imbler, who is an attorney at Spaeth and Doyle here in Denver. Did I get that right?
Close enough, Spaeth and Doyle, but yes.
Okay, Spaeth and Doyle. All right, and today we're going to be talking about basic probate, what triggers probate, some of the misconceptions that personal representatives or even just family members have once a loved one or somebody dies, and what to do with their assets and that sort of stuff. So, Dave, do you prefer Dave or David?
Either one is fine with me.
Okay. Okay. So why don't you just start out? Like, where did you grow up, and where did you go to college, that sort of thing?
Yeah, of course. So I've been growing up, or I grew up in Colorado, basically since I think my parents moved us here when I was in third grade. So I've been here my whole life. Lived out in Arvada. I went right in between Golden and Boulder. Um, I went to college at Colorado State University and studied, got my bachelor's of science in human development and family studies. Then I went to the Sturm, University of Denver Sturm College of Law for law school. And I think I graduated there in 2017. I took the bar, got passed, and then started this whole legal career.
Well, that sounds exciting. So, where have you practiced law? Any other firms before this? I'm going to be the one that needs the editing.
Yeah, no, absolutely. So I practiced first with the Denver Public Administrator's Office, and that's just an office. Lots of counties have them here in Colorado, and when there's really no one else, a family member can't take care of someone, doesn't know where the heirs are, heirs are feuding, or anyone is a family is just not getting along, they can come in and basically serve as a personal representative for an estate, or they can also serve as a conservator for someone who's incapacitated but still is alive and needs someone to help with their decision making. And so at that office, we saw hundreds and hundreds of people all the time, and you kind of got the hardest cases out of there. But it was great experience and a great place to start. They just do a great job over there. And then I went to a rather large firm that I didn't really agree with their practices. Left that firm pretty quickly, and then came over here to be of counsel with Spaeth and Doyle LLP, and that was really to bring my probate practice over to this their side of the real property, understanding real property law.
Well, one question that I've had for quite a while, and I haven't asked anybody. So I've seen that term of counsel quite a bit. What is that? Is that different than just saying that I'm with such and such a law firm, or is there like some disconnect or connection? Or
Yeah, it's basically of counsel means that I am my own attorney and that I work with that firm. Now, I would say that I probably do, probably could be labeled as something else as well, but that's just how we started it out since they hadn't ran a probate practice before. So I still kind of am my own attorney, my own entity, but with them, I guess I know it's still
so
probably
like an
confusing,
advisor, but you work with that office of their personnel.
yes, and usually of counsel is specialized in a certain area, and so
Okay.
my area just happens to be probate and protective proceedings.
Okay. So what is the term in Colorado? What does the term probate mean, and what triggers a probate here?
Yeah, so probate, basically probate, what I like to say is it refers to the probate court. And the probate court serves a few functions. They do estates, so when someone passes away, that would trigger a requirement to go into probate unless some, other exceptions or something, other planning was made before death. Or if someone is incapacitated and can't voice their opinions, they can't intelligently make or communicate decisions effectively for their own well-being, for their own finances. And so the probate court will also serve appoint a guardian or a conservator, and a conservator is just the financial person in charge, I guess. And then a guardian is a person who makes medical and placement decisions for the ward. And so a conservator is a protected person, is the person that we're talking about, and then a guardianship, a ward is the person we're talking about. And oftentimes folks need to do both. They need to get a conservator and a guardian just to allow for full decision making, whatever is in that person's best interest.
And can that be the same person?
That could absolutely be the same person, and I would say oftentimes it is. Now, if a public administrator stepping in or a third party fiduciary, usually they will only serve in one of the two roles. So you might have a public administrator serving as a conservator, and you might have a professional guardian serving as guardian. But when it's a family member, it's a lot of the times it's the same person doing both.
Okay, and what triggers the probate? A lot of people are under the misconception that if I have a will, I don't have to go to probate. It's all set.
And that is the biggest misconception in probate right there, is that if you have a will, you get to skip it. And the truth is, if you have a will, it means you're pretty much guaranteed to go through probate. The will is an instrument that the court will look at to decide what the person who passed away's intentions were and how they wanted to carry out their estate after death. And so when you have a will and your loved one passes away, you're going to take that will to the probate court and lodge it with the county that he or she was situated in, and then they will appoint a personal representative and have the estate be administered pursuant to the terms of the will. So I like to call the will the instructions for probate, not a probate avoidance. Now, of course, there are exceptions if there's a trust or there are exceptions, but generally a will means you've got to go through probate. It just means that Colorado law won't be deciding who inherits what and won't be deciding the probate procedure as much because the will already offers those instructions.
I tell people that I talk with, will is just your ticket to go to probate.
Exactly. That's a good one.
Well, I stole that from Bill Gross, who's kind of like my mentor. He's a probate expert in California. So I was like, well, that's a good analogy. So that's what I use. So how does probate in Colorado? How do we differ here than in other states across the country?
So, I might be a little biased as a Colorado attorney, but I would say that we have one of the best systems in the United States. We're a very advanced system. And what I really like about Colorado that doesn't really exist, I think other states are getting there, but not across the board, is just that in Colorado, we've designed a system where people can actually do a lot of this themselves. Not always, there's lots of times where it's just going to get too complicated and too crazy, but they have the forms here in Colorado to be able to do this without the need of an attorney. I know you got to be a little, you got to have a good eye and read through everything and go through the process yourself, but at least it's there. And in other states, I see a lot of times, you couldn't do it without an attorney. And the lag time is pretty high. I hear in California, it could take months and months and months to get before a court.
We're told like a couple of years sometimes.
Yeah, even years. And in Colorado, it's pretty rare. It takes over a month or two to get anything done. And the courts are so responsive, and we have a really good group of practitioners. At the Colorado Bar Association with the Elder Law Council and the Trust Estate Council, there's a really good group of people that are trying to make this the easiest, but also most safe process for everyone that's involved. And I just see that every day here, where, I hear about other states and it just doesn't seem like that.
Great. So what are some of the mistakes a family or somebody who wants to step up and become the personal representative, what are some of the mistakes they make early on in the process, say the first 30 to 60 days after somebody passes away? What's the timeline in that?
Yeah. So an estate can be opened at pretty much any time. So you could wait, let's say you're grieving or you got real life still happening to you. You don't have to just drop everything and open an estate, but we do recommend you do it fairly shortly after, a few weeks to a month or two after the decedent passes away. And one of the biggest mistakes is someone says, well, I was a child of whoever passed away, or had priority or something like that, or I'm an heir, so I can serve as personal representative, no problem. And the misnomer there is that if you're going to serve as personal representative, you have to allow anyone at your level. So if you have some siblings, or there's no kids and there's no spouse, but you're all siblings, you and your other whoever else would take to the estate, those folks have to also sign a renunciation and nomination of you if there's no will, or if there is a will and it says it's to nominate two people and it doesn't say co, then there's a chance that you'd have to get renunciation from the other person. So what I see a lot of times is folks say, I don't want to contact my brother from who's gone and we don't know where he is and we don't really like him.
Sure.
Most of the time, you do have to contact him, and you got to give him notice of this estate being opened if he has an interest in the estate, which is another reason using a will to take care of that before death is pretty advisable.
Is there a time limit that that person or those people have to get back to you as the personal representative or the attorney or the courts?
Yeah, so it depends on which procedure you're going to go through, and so there's two basic ones, and it's called. I just like to differentiate them between formal and informal
Mhm.
proceedings. On an informal proceeding, you can just go ahead and file it as long as you have those renunciations. You have everything. You have the original will if there is one. You can file it, and there's not going to be a waiting period for the appointment of a personal representative, or in other words, to open the estate. On the other hand, if you let's say you don't have the original will or you don't know where a cousin is or something like that, then you can go formally. And that just puts it on the court's docket for 2 weeks. So anyone who wants to object can. And if no one does object, then they're going to open the estate. And so that's the way you really notice those folks that you haven't talked to in a long time. If you can, as long as you can find their address or contact information, you just do that. And lots of times no one really objects, and the way the estate's going to be administered is the same either way.
Sure. A lot of people I come across, they think that going through probate's expensive, it's adversarial, it's a very slow process. Is that true, somewhat true, or not at all?
I would say very strongly somewhat true. And that's because it's all about the facts on the ground around that death. I mean, if there's what I like to say is that it's a very easy, simple process that almost anyone can do if it was made easy and simple for you before the person passed away. And so going through the courts, it's really not that difficult most times. The only time that it does get difficult, I mean, there's of course exceptions. There's other times it gets difficult as well. But the biggest one is if someone objects to the admission of the will or objects to the person's appointment as personal representative. Really, any objection, just that's where the costs explode. That's where it gets adversarial because this is it's family in nature.
Sure.
And so if everyone gets along and has a plan, or even if you don't get along, a lot of times I'm helping you try to get along just so you can forego those adversarial expensive disputes down the line.
That sounds good. So, what should families know about selling or transferring or even living in a property of the decedent? What should they know how to approach that and that sort of thing?
Yeah, so I would say a couple things. The first one is if you're living in the property or family members living in the property, just it's good to remember that the estate is technically entitled to rent from that person. It's when you're appointed a personal representative, you have a fiduciary duty to the estate to get the most amount of assets and money possible that the decedent owned and be able to distribute that out to the heirs or devisees or named beneficiaries. So generally, when someone's living in the home, everyone knew about it. It's fine. We're not going to charge a lot of money or, maybe not charge anything at all. Everyone can agree to that. But if you have one person who says, well, I don't really like that they were living in there and they should have paid rent, they have a claim for that. And so that's where it kind of comes into oftentimes it will make a dispute. The other thing to think about as well is just how long is the property going to sit? Because if you want to keep the property and lease it out, rent it out, absolutely fine. You are more entitled to do that. But then we would want to at least get the property out of the estate into your name, you and your family members, whoever it is that's taking the distribution. And the reason for that is the estate is supposed to be closed in 3 years. It doesn't have to be. We can reopen the estate. But generally, there's a tax base. You take a stepped up tax basis on the property or the date of death. So if you wait 2 years, and renting really wasn't working out, now you could be taxed on the gain of that property. Whereas if you sell it right away, it's you don't have that problem because there's not going to be any taxes owed. It was the date of death value, so it hasn't changed in value. You can go ahead and sell.
I think we have a case like that coming up.
Oh, okay. Okay.
up in Thornton.
Yeah.
Let's let's see, what else do I have here? You kind of segued right into that next question I have. So let's see. When conflicts happen, blended families, that sort of thing, estranged heirs disputes. Uh, how does probate help in those situations? I think you covered that a little bit, but I'm wondering, could you go into that a little bit more? Because I come across that quite a bit.
Yeah, of course. So, when we're talking about disputes, the court's going to resolve it. And so, what I like to tell folks is, look, you it's a win or a lose. You don't really want to put the court in that position because they're going to have to select a winner or a loser. And oftentimes, they will try to, at least in my experience, they'll try to split the baby, and that makes sense. But just to understand that what reaching that resolution really does help obviate the fees and the costs and the pain and the turmoil that goes along with these proceedings, because a lot of times these folks are bringing up things that can't happen long ago. I mean, there's deep-seated resentment there and all of that. But the probate court will set a hearing, hear what the parties have to say, have a case management conference, so, for discovery and, just other procedures of the court. You'll go through that process, and then you have generally a pre-trial conference, and you just make sure everyone's ready for trial. And then if you really can't have a settlement or figure something out, you do go to trial, and there will be a winner and a loser.
So let's look at it. If there's a family out there and everybody's healthy, what can they do now to prevent this down the road when something unexpected does happen, whether that be incapacitation, a car accident, a massive cerebral accident, stroke, etc.
Mhm. So, my number one advice is to get a power of attorney for financial and medical matters in place for any healthy, fit. You're not thinking about death. Why would you? And if you can possibly get those two documents, I find them to be the most important, because people are tending to lose capacity before they pass away at much greater numbers these days. And so, who makes those decisions while you're still alive is paramount to everything else. At least in my book, when you've passed away, you're not here anymore. But when you're still alive, you want to make sure the right decisions are being made for you. And Colorado has statutory form power of attorneys. They're anything that could just obviate the need for a conservator or a guardian, because if you have those forms, you don't have to go through a conservatorship or guardianship. And so, getting those established early and changes as needed, I really strongly suggest it. And then on the estate side, a will, speaking with some sort of estate planner or other attorney that can help guide you through what is perfect for your scenario, because there's a lot of things that can be just completely avoided just through a few paper documents. And in Colorado, our laws are really, at least my bias self thinks, they're very good. And so we don't really have to. There's lots of times where a trust or something expensive isn't necessary, and it's just about getting your basic affairs in order, so you can tell the court, once you do pass away, through this will, that this is how I want things to go.
Okay. So you mentioned trust there. What does a trust do, and what are the costs? Usually I tell people, even I'm not an attorney, but I tell them, it depends on how complicated it is, and it can be on the low side about $3,000.
Yeah, that's exactly right. I would say a fairly basic trust can be around that price, but oftentimes we see it starts at 5, and then it could be up to 10 and 15. You never know.
Sure.
And then, sometimes that's absolutely necessary. There's certain people with certain assets, or oil mineral rights, or something out of state or in another country, or they just prefer their privacy. And so, what a trust can do is basically serve as an estate in a way, as in, instead of going through the probate court, you're going to go through the instructions of the trust, I think would be a fair way to put it. And then that trust also fosters privacy, because in an estate, you open the estate with the court, and really anyone can view that. Anyone can go in there and see what happened and see the will and that stuff. Whereas a trust, you don't really have to do any of that. You can operate completely outside of the court. And so in a lot of states, that makes a lot of sense, because the courts are so slow, or they don't just have
Mhm.
they just have those problems where a trust you can just go ahead, get going, and take everything over. And then the other thing with trust, if you're trying to provide for someone, let's say you have a minor child or a child that has some dependency or disabilities, that trust can provide for them over time instead of all lump sum at once. And so the estate generally, it's supposed to close, it's supposed to be administered effectively and expeditiously. And so you can't really just hold money in there for years and years and give out a certain amount to the heir. Whereas a trust, you can start structure what they get and when, and then you can have a private third party trustee or really any family member serve as that decision maker of what they should end up getting. But here in Colorado, unless you do have that specific situation, and some others, out of state real property, which you could go back and forth on whether it's worth the cost of a trust. But generally, I would just say that I would always seek, if you're going to establish a trust, I would seek, some guidance and at least make sure that it is worth it for you, versus just a normal estate plan with a will and, powers of attorney.
So powers of attorney, it's my understanding they end when the person passes away. How
Yes,
does
that's correct.
and so what's the difference with that and the trust? My understanding is the trustee, the person who develops the trust, writes out the rules, and it takes effect immediately. You don't have to wait until somebody passes away.
So it depends. Most trusts that we see are what they call revocable trusts first. So if you make the trust, you're saying, okay, this is my trust, but I can still access everything inside the trust. I can still direct the trust. I still have complete power over the trust. And then once you pass away or you're deemed incapacitated, and usually there'll be language in there, that's where you'll say, or you'll see that the trust becomes irrevocable. And when it's irrevocable, then you can't change the terms. You can't do anything with it. It has to be administered just to what it says on the paper. And so the way I like to think about that is, trusts a lot of times are for tax situations where you're trying to, avoid, state
Tax
taxes or whatever it
avoidance. There
is.
you go.
Yep, exactly. And
You can say it. It's okay.
okay. Yeah. So if you're looking for tax avoidance, the law says, well, if you put this in an irrevocable trust and you title it to the trust, so you take your home and you say it's going to the trust of John Doe, the trust now owns that. You don't, so you're not going to be taxed on it. The trust would technically be taxed on it, or it may not be taxed at all because if it distributes right after death, you get the stepped up basis and all of that. So it's it's a good tool in a lot of different states, and it's still a good tool here in Colorado for certain situations. It's just the cost and the time, because you have to, let's say you go out and buy a new car. If that car is not in the name of the trust, it's going to your probate estate. And so you can have a residuary will to basically, or not a residuary, sorry, I'm about to cut this out. You can have excuse me, you can have a pour over will, and then a pour over will take all the estate assets like a car, your furniture, something like that, and then it'll just go right back over to the trust. And so that's what we usually suggest in those situations. But you buy a new home or you set this up, it's been 20 years, you forgot about it, and that property is not titled to the trust, that investment account's not titled to the trust, it's going to the estate. And so now you got a trust that isn't really worth anything because it wasn't funded correctly. And then you have an estate that you're trying to avoid and you have to go through anyways. And so it's just something that we really like to plan for here. If you are going to have a trust, we make sure that everything is in there. We make sure everything's titled over. And that also becomes part of the cost of a trust is just making sure all these assets are in there and exactly where they need to be.
If somebody has a trust, it's funded properly, say they come to you and you do A to Z for them, is there a time period, like every 3 years, every 5 years, that you would review that for them, or they could bring the documents in and you could update or make sure everything's still lined up?
Yeah, absolutely. And we recommend you kind of do that every 3 to 5 years. And then if there is a substantial change in the law or something that's could be coming into effect that we might need to prepare for, we will bring you in and discuss how we deal with it, no matter
Okay.
what that is. And so, yeah, I guess I would say if you have a lot of life changes, we'd ask you to, come see us, let us know. If we see something on the legal side or, just rules, regulations, then we will let you know.
Okay. So, and then once somebody passes away, who should the family contact first as far as the professionals? A lot of times it's a realtor, sometimes it's an attorney. I'm not really, I'm like I keep saying, I'm not an attorney, so I don't want to give that advice. What would you recommend?
It's a tough because I could recommend talking to an attorney, but you might not know an attorney yet in this area. I mean, a lot of times it's the first time these folks have ever dealt with any sort of legal case or
Mhm.
legal anything. And so if you could talk to an attorney first, I'd say that's a great place to start. But what we find is a lot of times it starts with the realtors because the first question is, well, what are we going to do with this vacant house? And how do we get started? And so I don't have it. That's still great too, because a lot of realtors, they have the resources to contact folks like us if they haven't seen this already before, which a lot of them have, and so they can at least get things kind of started. Here's where you kind of need to start, or here's who you need to call. And I think that's a great place to start as well. And also this place that just a lot of people do.
Do you find it, do you work with a lot of realtors that have that probate experience, or because I come across realtors, they do probate, but they do like one or two, maybe a year if somebody they know is their mother or somebody passes away.
Yeah, I would say, there's a few like yourself out there that do have great probate experience and just do this. You could tell they're doing this more than once or at least more than once a year. And what I find is with the younger realtors too, and nothing against them whatsoever, but they don't have I don't think they have the connections that, an older gentleman or woman would have just
Thanks.
to be,
Yesterday I
yeah.
turned 60. Thanks a lot.
Oh, well, happy birthday. Happy birthday. But
Thank you.
just that the clientele is usually a little bit younger with those younger realtors, and
Sure.
so and I wouldn't blame them for not seeing this or not having it come across too
Yeah.
often. So there's definitely a difference in quality in some, or maybe just experience, I should say, but it's nothing an attorney can't help them through. But the ones that do have that experience of seeing this again and again, they really understand. Well, we need to. Oof, that's something we should talk about, or we'll call an attorney right now because we don't know if you can do that yet. And those warnings kind of upfront are just so crucial to making sure that things don't get worse, in that situation.